All right, I think it's time to get started. So, Nurinj everyone, Womaninji, Netul Mukta, Paul Payton, Naju Gunai, Naju Monero, Naju Tunganai Waru Gunai Work. My name's Paul Payton. I'm a Gunai Monero man. I want to acknowledge all the traditional owners from all the countries that we're dialing in from today, and honour our ancestors, both past and present, as we work towards a treaty with the state, and importantly, what are some of the elements that contribute to that? I'm pleased to welcome you all today. It's the fourth in a series of 6 lunchtime webinars that we've developed, which is informed by traditional owner engagement meetings that were held back in 2019, as well as what we've learnt since then. And as a contribution towards the treaty process, and to stimulate some discussion and thinking around some of those processes. For us as a statewide body that convenes and advocates for the rights and interests of traditional owners, this webinar aligns most strongly to, not uniquely, but to one of our 4 pillars of focus, which is being knowledge sharing. Which is designed and focused on enabling a more connected, informed and innovative traditional owner corporation and communities more broadly, through the promotion of resources and events and information sharing opportunities such as today. And today's presentation, Aboriginal Control of Aboriginal Affairs, is one of the 4 papers. They're already on our website for you to download those and have a read of those if you haven't already done that, with the final 2 currently under development, and we'll distribute and present those in the not too distant future. But I guess specifically today's presentation, we all know that Aboriginal governance has existed and sustained our communities and country for thousands of years, and this system was disrupted through colonisation. The recent establishment of the Uruk Truth and Justice Commission will bring to light a lot of those impacts and make specific recommendations. I think returning back to that system of Aboriginal governance underpinned by self-determination is what we as Aboriginal people have been advocating for generations, and that we should have control of our own affairs. At this time, a negotiation of a treaty would differ from previous attempts to accommodate traditional owners' claims. Primarily, it implicitly recognises Aboriginal people and traditional owners as distinct political entities, and with whom the state can reach a political settlement. So, treaty will be all-encompassing of all those rights and interests that have been advocated for many years. So, the purpose of the paper and the presentation today is to examine how we can effectively and practically achieve control of our own affairs in the context of treaty, which is now underway, as we all know. So, without further ado, I'll hand it back to Dan, and who is General Counsel at Federation, to deliver the presentation to you today, and hope that you get a lot out of it, and we look forward to your questions at the end of the presentation. So, back to you, Dan. Kanipa.
Thanks, Paul. Much appreciated. I'd also just like to acknowledge country and elders past and present. I'm on Wurundjeri country today. As Paul said, today's paper is about Aboriginal control of Aboriginal affairs and focusing on the potential to create an Aboriginal Parliament and Public Service. Just for some reason, this slide doesn't want to move. There we go. So just a word on these discussion papers and their purpose. So we're not putting forward these papers as a position of the Federation or Federation members or traditional owners. Really, what these papers are discussion pieces, and they hope to contribute to the thinking around treaty making in Victoria. One of the kind of focuses that we're trying to do in these papers is put forward concrete proposals about how treaty might work. In the treaty space, there is a lot of rhetoric, words such as sovereignty, self-determination, etc. And the ideas of this sort of paper series is to try to express what those concepts might look like in practice, how they might work in the real world. So as Paul said, there's 6 papers in total. The first 3 papers are available on our website, and I think through our YouTube channel you can also see the webinars that were presented on them. Today we are looking at paper 4, Aboriginal Control of Aboriginal Affairs, an Aboriginal Parliament and Public Service. Our next paper will be on local treaties or traditional owner treaties, and discussing a potential framework for those. The paper's been prepared now and will hopefully be available shortly. And then our 6th paper will essentially revisit the previous 5 and kind of try to bring it all together as a comprehensive model for further discussion. So just an overview of the proposed model that we've developed so far in these papers. The first and sort of central piece to that model is the development of a statewide Aboriginal democratic body that would represent traditional owners and Aboriginal people across the state. We refer to that as the Treaty Representative Body, or the TRB. It's just what we call it for the purposes of these papers. First Nations Assembly. Indeed, this body could be the First Nations Assembly or some evolution of that body, but the current body sort of stands as a bit of an indication of what we intend for that body to do. Now, we would see that body as entering into a statewide treaty with the Victorian government, and that would be a sort of high-level treaty dealing with statewide issues. We lay out this sort of proposal in our first paper, paper 1, which, as I said, you can find on the website. The other thing this statewide treaty would do is it would establish the TRB as a sovereign body, and that means it would have to have some form of sovereign powers, and that could be the power to make legislation, it could be a voice to the Victorian Parliament, or it could be reserved seats in the Victorian Parliament. The statewide, and we discussed that in paper 2, which you can delve into that into further detail. The statewide treaty, we would suggest, should also recognise Aboriginal rights, which we see as the entrenchment of UN DRIP. The entrenchment of UN DRIP in Victorian law, and both as individual treaty rights within the treaty itself. We look at that in paper 3. Today, as I said, that we're looking at Aboriginal control of Aboriginal affairs. The statewide treaty should contain a process to hand over control of Aboriginal affairs. And we largely see that happening through the establishment of an Aboriginal Parliament. So the TRB is established as an Aboriginal Parliament, and below that Parliament, it would be supported by an Aboriginal Public Service, which would, and transferred to that public service, would be all the resources and powers that currently sit within the state of Victoria. And that's what we're going through today. And as I said, the final paper will be on a framework for local treaties. We see these as being collectively negotiated with individual traditional owner groups. The paper will draw on some of the lessons I think that we've learned from the Traditional Owner Settlement Act about how that process is rolled out. We would see the Settlement Act as the rights achievable under the Settlement Act as very much a flaw, and they need to be developed to provide sovereign rights on country, which would make them a treaty. So that's the model. Yeah, now just moving into today's paper itself. Now, as I said, the focus obviously of this paper is about establishing an Aboriginal Parliament, and I think the essential feature of a parliament is that it has the power to create laws. That's what differentiates a parliament from other types of bodies. It can make law. Now, around the world, we do have numerous examples of Indigenous parliaments. So we have experiences in other nations we can draw on. And those particularly are in the United States, Canada, and Scandinavian countries where there are operating Indigenous parliaments. Each of these examples, they tend to have similar features, and I'll just go through some of what I think those features are. The first is that they all have a level of constitutional protection or recognition. So in the United States, Canada, Norway, I've put up the relevant sections there. They are where the Constitution will recognise the right for Aboriginal people to have treaties and protect those treaties as part of the constitution of the nation state. Another feature that's common is that there is some level of oversight or intrusion by the settler nation. A kinder word for oversight or intrusion might be relationship. There needs to be a relationship between the settler government and the Indigenous government. And sometimes, well, quite often that relationship will involve a hierarchy. And we see that in the United States where state regulation is starting to encroach on Native American reservations, which are sort of governed under a First Nation sovereign. We see it in Canada where all of the self-government that happens there needs to operate within the Canadian Constitution and has to be in harmony with Canadian law. The third feature that I think all of these Indigenous parliaments have is that they tend to be land-based, and that is they will be in a remote region of the country, far away from the sort of centre of the settler cities and so on. There will be a majority or a significant Indigenous population. Even where you don't have those two conditions, you will have an Indigenous polity that has a significant land base that they've managed to retain through colonisation. And the way that the Indigenous Parliament will work, or the jurisdictional sovereignty will work, is that it's marked out on a map to cover a geographical area. Now, when you look at these three features that sort of pop up in the international space, we see that then a lot of them we don't really have in Victoria. We don't have constitutional protection, and in fact, I think what we'll run into are probably some constitutional limitations about how we can operate. Oversight will certainly be a feature, I think, of a Victorian model, and we need to think, therefore, about how that oversight how much oversight should be tolerated, and we need to clearly sort of demarcate those areas where the traditional Parliament or Aboriginal Parliament should have unfettered independence. And we don't necessarily have a land base. In terms of the model that we've put up, we're thinking of this Parliament at a state level. So at the state level, there will not necessarily be a land base. Some traditional owner groups will have a limited land base, but even then, not really on the scale that we see overseas, where you can administratively, it sort of makes sense to sort of mark off an area and allow it to enjoy separate governance. So that's not really a feature of the Victorian situation. So we'll focus on legislative powers, and I think legislative powers need to be a part of a treaty outcome. They're an important marker of sovereignty, but we should also recognise that they're only one tool in the toolbox. There are other forms of power that are going to be important to achieve self-determination. Just practical things like resourcing, the ability to design and implement policy. There's a lot that can be achieved by an organisation that has the resources and can develop and implement its own policy. And a lot of work can be done in achieving self-determination through those methods. So just a quick overview of the paper and what I'll speak to today. There's a lot of information in this paper, so I'm going to be forced to go through it relatively quickly, for which I apologise. And I'll try and leave space at the end for some questions. But as I say, there is a lot to get through. So I'm not following the exact structure of the paper because I'm trying to get to, I guess, the interesting or key points. But the first thing we'll do in just diving into a bit more detail around some of the things I've just said, we're going to look at the experience in Canada and the approach of the federal government there. We're going to look at some of the constitutional limitations that might sort of frame the way an Aboriginal Parliament needs to be established in Victoria. We will have an attempt at trying to define the scope of the TRB and where we think the legislative power should be and what other types of powers there should operate with those. And finally, we'll put up a legislative governance model, which would be a sort of a potential process by which the TRB could. So moving on to Canada, and just a quick word on why we've chosen to focus on Canada. I mean, one obvious reason is there is a similar legal system. They have provinces and territories and a federal government. We have states and territories and a federal government. It's a very similar legal system in that respect. but they also have adopted a very sort of wide approach to self-government at the federal level. And so that approach from by the federal Canadian government gives us a lot of insight into different ways of sort of cutting up Aboriginal self-government. Canada also presents an interesting case study that's just kind of developing at the moment. As I said before, there is this norm of these parliaments operating in remote areas and having a defined land-based jurisdiction. There's current negotiations going on between the Canadian government and certain Métis nations. The Métis are a landless Indigenous group in Canada, and they are making efforts to essentially bring in self-government without necessarily tying it to a land base. So in Canada, Section 35 of the Canadian Constitution recognises and affirms existing Aboriginal and treaty rights. And in August 95, the Canadian government acknowledged the inherent right of self-government for Aboriginal people of Canada. They defined the Aboriginal people of Canada to mean First Nations, Inuit and Métis peoples. And in 95, they released this self-government policy guide. And that guide adopts a broad approach to concepts of self-government and basically puts forward three broad streams that the Canadian government will entertain when it's starting to think about self-government for Indigenous people. Those three broad streams are what they call public government, jurisdiction over land base, and institutional arrangements. And I'll go into describing what each of these three streams involves. So public government is essentially the government of Canada will consider creating a separate territory, which would be recognised as part of the Canadian federal system. So this would be the equivalent of Australia creating a new territory or a new Aboriginal governed territory. They give this option only in the remote north and where there is a significant majority Indigenous population. So the example is the Nunavut territory. This was created, I think, in the 90s. It has the same status as other territories within the Canadian system. It's located in its very remote north. It also has a population of 83% Inuit. So, you know, the Inuit were demanding self-government rights. Rather than create a separate Inuit government, they've created a territory of Canada. And obviously that territory is heavily dominated by Inuit people. Also in Canada, and probably more commonly, is this idea of a jurisdiction over land base. So the Canadian government, where a group holds a significant land base, the Canadian government will enter into arrangements where that land base then becomes subject to the jurisdiction of an Indigenous government. This is more available in the south and where groups continue to hold significant bits of land. We see this, an example of this is the British Columbian Treaty process. It's also evident in the Yukon Territory. In the Yukon Territory, there's 14 First Nations. In '93, they signed an umbrella agreement, and each of those 14 nations then went on to negotiate and sign individual self-government agreements. And those agreements allow First Nations to enact legislation in a number of areas, such as tribal justice, education, health, social services, and so on. Now, that's the first two streams that Canada use. The third is this one called institutional arrangements, and this is basically designed or will be designed to where a group doesn't have a significant land base over which it can exercise jurisdiction. The idea is that institutional arrangements will be put in place that give a group the ability to control and influence the important decisions that affect their lives. As I said, it's available where a group doesn't have a land base, but it is yet to be actually introduced in Canada. Although it's been in the Canadian government policy since '95, it's yet to actually be implemented anywhere. As I said, there are groups in Canada without a land base. Colonisation has essentially left them landless. The Métis are the most prominent example of this. they have homelands through Ontario, British Columbia, the Northwest Territories and Northern United States. So as I said, this hasn't been put in place yet, but in 2019, 3 Metis governments in Ontario, Saskatchewan and Alberta entered into recognition and self-government agreements with the federal government. These agreements do not of themselves immediately deliver self-government. Instead, what they provide to the Metis is a pathway to get there. So the first step in this under these agreements is that the group can be formally recognised, that the agreement will be ratified internally by its citizens, and it provides jurisdiction over internal self-government areas. So that essentially means that they have the ability to determine their own citizenship, leadership and operations. So as you can see, this first part is about these nations and getting their internal governance sorted out. Once that's achieved, the agreement set out a process for negotiation of certain jurisdiction. That, sorry, my internet connection is, I'm not sure there's much I can do about that. Yeah, so the next step under these Metis agreements is that the Metis governments will be able to negotiate jurisdiction over a whole range of areas. Where are we not working? And the list of areas over which the Metis are able to have jurisdiction is long, but it'll be language, culture, heritage, education, housing, and so on. Exactly what their jurisdiction over these areas is going to look like in practice is not determined, but drawing from the self-government guide, it seems the intention is that the government will devolve programs and services to these governments to provide, and to allow them to develop their own institutions to provide services. It would also seem likely that the Metis may be able to pass legislation in the policy areas listed above, probably limited to the extent that it's going to affect the Metis people. So that's a broad overview of the Canadian system and that there are 3 streams of government. I draw particular attention to this Metis example because I think it probably more closely reflects what we see the role of the TRB being in Victoria when it won't have access to a significant land base. So moving on, and I'm conscious of time. As I said, there's a lot in this paper, but I will try and just briefly speak to the way I think the Constitution is going to interact with the ability to set up this Aboriginal Parliament. As we've said in previous papers, there's nothing in the Australian Constitution that prohibits a state from entering into a treaty with Aboriginal people, but there's also nothing that facilitates the making of treaties. The Australian Constitution is largely silent, well, it's not largely, it's completely silent on this issue. So although it's not prohibited, there's also nothing in there that helps this process along or would support this process. And of course, as I said, that differs from other settler nations like the US and Canada and so on, where they do have constitutional recognition of treaty rights. This means there will need to be caution in the design of the TRB and its legislative power to make sure it's compliant with the Australian Constitution. It will also have to comply with the Victorian Constitution. However, as I'll go through in a moment, the Victorian Constitution is easier to amend. And of course, the Victorian government is also a party to the negotiations. So just by way of a broad overview of the Australian Constitution and what it does, basically it's a document that divides divides lawmaking powers between the state and federal governments. And if you think of its history, the Australian Constitution comes about because 6 independent and individual colonies get together and they strike a bargain about how they're going to set up this new Commonwealth or federal government. Before Federation, each colony had its own parliament, and those parliaments were unfettered about the sorts of laws they could make. They could basically make laws about anything. Their only limitation was that they couldn't make laws inconsistent with British law. So when these colonies get around the table, they're very carefully negotiating what they're going to hand over to this new federal government and what powers they're going to keep and exercise as state governments. So the Australian Constitution really sets out three broad areas of different powers. The first is exclusive powers. So these are powers that are held only by the Commonwealth. The second is concurrent powers. These are powers that are held jointly by the states and Commonwealth. And the third is residual powers. So that's anything not mentioned in the Constitution, which is retained by the state and will stay with the state. So the sorts of things we see in exclusive powers are all the I suppose obvious things that a modern nation state wants. That is powers over defence, foreign policy, currency, citizenship, and so on. In the middle, we have concurrent powers. So both the states and the Commonwealth have the power to make laws in relation to these areas. And so you'll see splits like in education, the Commonwealth is responsible for universities, the state is responsible for schools and teachers and so on. In health, the Commonwealth is responsible for pharmaceuticals and the state's responsible for hospitals. Now, because they are making laws within the same areas, there's obviously the potential for conflict or for overlapping laws. So Section 109 of the Constitution says that if that happens, the federal law will take precedence, and essentially the Commonwealth can sort of move into these areas and push the state out if it chooses to. Finally, with residual powers, these are the things the states have retained, and it's all of the usual things we associate with states: Crown land, public transport, police, prisons, ambulances, that sort of thing. Also, which will be important in a moment, Section 106 of the Constitution allows states to amend their own constitutions and set up their own parliaments as they see fit. So that's that ability that parliaments in each state can essentially organise their own affairs as they want to. So Section 106 allows the states to set up their own constitutions. In Victoria, this is done as an act of the Victorian Parliament through the Constitution Act 1975. So the Victorian Constitution says that, subject only to the Australian Constitution, the Victorian Parliament can make laws in and for Victoria in all cases whatsoever. So the only limits on the Victorian Parliament are those in the Federal or Commonwealth Constitution. And I've just been through those. It's areas where the Commonwealth has exclusive powers, and also where there's concurrent powers and the Commonwealth has made law that is inconsistent with state law. So the Victorian Constitution also goes on to, obviously, it sets up the lower house, the Legislative Assembly, and the upper house, the Legislative Council. It sets out rules about how members are elected and about how the Parliament will generally operate. Because it's an act of Parliament, the Victorian Constitution can be amended by the Parliament. The process would simply be passing another bit of legislation that amends the Constitution. But in 2003, they brought in this concept of entrenched provisions, and so some provisions within the Constitution are entrenched, and there's a special process by which they are able to be changed. That's particularly there they were trying to sort of protect the more sort of democratically necessary components of the Constitution. One of them being the change to the number of MPs or the way that elections take place. So if there is an entrenched provision, there are different levels. Some can be changed only by an absolute majority in both houses. Some require a 60% majority in both houses, and the more significant components of the Constitution can only be changed by a referendum of Victorian citizens. So one way that's a lot of information about constitutions. One way to try and tie it together in a useful sense, I think, is probably to apply it to some of the ideas we've had about what powers the TRB might want. So as I think I pointed to this earlier, that might be a voice to the Victorian Parliament, or it might be the ability to take up reserved seats in the Victorian Parliament, or, as is the major focus of this paper, setting up an independent Aboriginal Parliament. So just thinking what impact the Commonwealth Constitution and the Victorian Constitution would have on trying to implement these particular proposals. If we look at one, the idea of a voice to Parliament, The Commonwealth, Section 106, says that the state parliament can design its own lawmaking system. So the Commonwealth Constitution really has nothing to say over that concept. And the Victorian Constitution would require a majority in the lower and upper house, and it could be changed to accommodate a voice to the Victorian Parliament. So, at least constitutionally speaking, that's a quite straightforward process. It shouldn't be a problem. If we look at the second idea, the idea that we have reserved seats in the Victorian Parliament, once again, Section 106 comes into play, and the Commonwealth Constitution doesn't really have any role. But a change in the number of MPs would require a referendum. So that would need to go to a referendum of Victorian citizens. Constitutionally, that's all very straightforward. There is a process to make it happen. There might be political issues around the referendum, but from a constitutional perspective, it's all quite straightforward. The third idea, the idea of an Aboriginal Parliament, is a little bit trickier. The Commonwealth Constitution doesn't have the ability to sort of recognise other parliaments or other sovereignties. The only process it has is a process of admitting new states into the Federation. And we think that's not really what this process is about, and it's probably unlikely to be supported by the Commonwealth anyway, I'm sure. And of course, the Victorian government doesn't have any power to create a parliament that's equal with itself, or that could be considered as part of the Federation. It's just simply the fact that these processes don't exist in our constitutional documents, so there's sort of nothing there to do it, which makes it a little bit trickier. But there is a fairly clear path, I think, about how this could operate. And basically, it would be through a process of delegation. So the Victorian Parliament could delegate powers, including legislative powers, to the TRB. And the concept of the delegation of powers from the state even legislative powers from the state is not uncommon. Indeed, the state is delegating powers all the time. It's just delegating administrative functions to statutory authorities. An example that would probably be well known to this audience is the Aboriginal Heritage Council, which has delegated powers to make administrative decisions about whether applications are approved for RAB status. However, the state can also delegate legislative functions, and we know this because they do it in the Local Government Act 2020, Section 71. A council may make laws for or with respect to any act for which a council has a function. So this is a process by which the TRB could be given the power to make legislation. Potential drawback, though, is because it's a delegated power, it's a power given by the Victorian Parliament, there is also the potential for the power to be taken away, or for the power to later be limited by amendment or something. We see, as I said, in Canada and United States, we see a level of oversight or intrusion from the settler government. So that's a common feature. That's not unusual. But in these other jurisdictions, they have constitutional protection, which means once the treaties are established, they are essentially protected and can't be pulled apart. Without similar protections in Australia, I think any state-based treaty is always going to have this vulnerability. But there's really not much we can do about that without constitutional change at the Commonwealth level. So very, very conscious of time now, and I'll try and skip through this final sections as quickly as I can. But in starting to think about the scope of an Aboriginal Parliament, about what it would do, we've drawn on the Victorian Aboriginal Affairs Framework, which is what's known as the VAF. This document basically examines all current government policies in Aboriginal affairs, and its role, what it's trying to do is align them in an overarching whole of government framework. You can see there in that table a list of current government policies that have been prepared by various departments. There's education policies, health policies, justice policies, and so on. Since 2016, Victoria has followed a policy of self-determination, and that means that increasingly these policies have been developed in partnership or consultation with the Aboriginal community. And they do this through what we call consultative bodies. They're listed in the right-hand column of that table. Those bodies are basically created by the departments. They'll consist of Aboriginal community members and perhaps experts and specialists in their particular area, and they will consult and have a say on the development of those policies. So the VAF is taking a wide view of this space, and it's trying to, create order and an overarching sort of government policy. And in doing so, it creates this idea of the 6 domains, and it places each of the policies into one of these domains. So of the 6 domains, there's children, family and home, learning and skills, opportunity and prosperity, health and wellbeing, justice and safety, and culture and country. The VAF also, as its goal, the end self-determination policy of the state is to transfer power and resources in each of these 6 domains to the Aboriginal communities themselves. The VAF doesn't say how that will occur, and that's quite proper because how it occurs needs, I think, to be a self-determined process. But it would seem to us that treaty and the establishment of an Aboriginal Parliament would be an obvious and good vehicle for the transfer of these resources and powers. So we adopt the 6 domains just as a way to think about the scope. It might not be perfect, but it's a way to sort of start to get into thinking about where the powers of an Aboriginal Parliament should be. It also gives us an opportunity, I think, to think about the relationship between an Aboriginal Parliament and local traditional groups. The Aboriginal Parliament wouldn't be operating alone; it would be operating at a state level, but there would also be treaties at the local traditional owner level, and so there would need to be a relationship between those and a discussion about what's appropriately left to the TIB and what do traditional owner corporations, traditional owner nations want to retain as part of their treaty work. We would say from these 6 domains, the 6th one, culture and country, obviously and squarely sits within the ambit of traditional owners. It's about, culture and country will be at the core of what they do. In the other 5, individual traditional owner corporations may have aspirations in these particular areas, but they're nevertheless things that impact Aboriginal people across the state at a very broad level. In addition, there is spaces in which there are already well-established ACOs, consultative bodies, and there's specialised Aboriginal organisations that have been in these areas for years, and they have decades of experience. So we would see the TRB taking on a coordinating role in each of these 6 domains, and would be incorporating and empowering, both interested traditional owner groups and the existing specialists and ACOs to lead self-determination in these areas. We think this is mutually beneficial. TO groups are going to be strengthened by operating collectively, and existing expert bodies and ACOs are going to have increased authority by being placed within this democratic Aboriginal structure, and they're going to have the force of treaty rights behind them. For both groups, we hope that, instead of moving from this position of lobbying government, they'll be moving into a position of having the power and being able to directly implement their policy solutions. Now, I'm going to try and move quite fast. Again, the focus of this paper is on legislation, but we shouldn't become get tunnel vision about that. There are different types of power that I think are equally important, if not, well, maybe not equally important, but also essential, I think, to self-determination. So obviously there is legislative power. There is also the power to make administrative decisions, policy design, and administrative functions. Legislative power is obviously the power to make law. It's currently carried out by the Victorian Parliament. Administrative decisions is the power to administer law and to make the decisions that sit within statutory regimes that need to be made. An example is what the Heritage Council does in the under the Aboriginal Heritage Act. Policy design and the ability to approve policy is obviously, I think, going to be a central core focus of what the Aboriginal Parliament does and how it actually achieves the outcomes it wants to see. Currently, that sits within government departments, and that would need to be devolved to what we call an Aboriginal public service. And finally, of course, administrative functions. This is basically just to say that you need the resources and you need the bodies on the ground to actually be able to make things happen and to do things. So our proposed legislative governance model, we would have an Aboriginal Parliament. It would have jurisdiction over the 6 domains. And within those 6 domains, and to the extent it affected Aboriginal people in Victoria, it would have the power to make legislation, it would have the power to appoint administrative decision makers, and it would be solely responsible for policy design and administrative functions. In terms of its relationship with the state government, we would see it has complete jurisdiction in the 6 domains, and outside of the 6 domains, we would suggest it have a voice to the state government. So anything that the Victorian government is doing outside of those areas, the Aboriginal Parliament has a voice. But we would also see this voice as being reciprocal. So this concept of a reciprocal voice would work by the Aboriginal Parliament having a voice on matters outside the 6 domains, and the Victorian Parliament having a voice to the Aboriginal Parliament within the 6 domains. And we don't see that voice as being binding. Essentially, it's a the Victorian Parliament would have a right of consultation on actions taken within the 6 domains, but wouldn't have power. The idea of transitioning power, of sort of moving from the current position we're in to the one we're describing, again, taking the 6 domains as a starting point, we would see that the first step is transferring ministerial responsibility. If we think of these domains as essentially portfolio areas, if we think of if the TRB is an Aboriginal Parliament, these are the portfolio individual ministries, and the TRB could begin to develop internal departments around these areas, headed up by a member of the TRB executive, and their role would be equivalent to that of a current minister. So thereafter, for a period of perhaps 12 or 24 months, the Victorian minister and the TRB minister could engage in a co-governance, and they would have to jointly approve all decisions in their relevant policy area. But the main function of that period, or the main purpose of that period, would be the transfer of resources to the TRB, out of government and into the TRB to establish an Aboriginal public service. And at the end of that period, it would be the TRB minister who was solely responsible for that area. And hopefully beneath them, they now have a functioning department, and they're capable of producing all of the policy design and administrative functions necessary to run their particular domain area. With this new level of experience, the TRB could then take up legislative powers with each domain and begin a process of reform. So once that transfer of resources is complete, we see these legislative powers kicking in. There's no real need, I think, to sort of preempt what that reform might look like, or what the particulars of reform might be. But just as a bit of a method for thinking about how it might occur, if you take Domain 1, for instance, Children, Family and Home, you look at the legislation within that domain. So you have Children, Youth and Families Act, Family Violence Protection Act, and so on. And below that, you have the current policies that are designing the way that those acts are applied to the Aboriginal community. So the first thing that needs to be done is to benefit with this not serving Aboriginal people within this domain. I think an obvious example is, say, the appalling rate of child removals. Why is that occurring? Is it an issue within the legislation? Is it an issue within the existing policy? If it's an issue within the existing policy, that now sits entirely within the TRB, and that they're able to redesign that policy and implement it without any inside interference. If the problem is identified within the legislation, the TRB also has the power to create new legislation or perhaps amend the offending sections of the Victorian legislation. This, I think, gets a bit more complicated because starting to make legislation is likely to invite the interest of the Victorian Parliament, and we're likely to see, again, a level of oversight or intrusion. How do we deal with that? I mean, it is a feature of all international examples. Then there has to be a relationship between the settler nation and the Indigenous nations, and it will likely be a feature of the Victorian model. The idea, I think, is to try and get a balance that respects the independence and sovereignty of the Aboriginal Parliament, and also constitutional limitations. So we think about trying to achieve that balance through a scale of decision making. The idea is that this scale of decision making would take into account the interests of all the parties. The way we see it, the Aboriginal Parliament is interested in the well-being of the Aboriginal and traditional owner community. The Victorian Parliament is interested in what impacts on Victorian citizens. So where a matter is internal to the Aboriginal community, it should essentially be completely independent. And where there may be an impact on non-Aboriginal Victorians, the state is entitled to perhaps greater involvement. So the scale of decision making, we see three categories of decision. Category 1, internal to the Aboriginal community. Category 2, relating to how the state interacts with Aboriginal people. And Category 3, decisions that will impact on non-Indigenous people or interests. Category 1, we see that there should be complete and unfettered independence of the Aboriginal Parliament. The Victorian Parliament can express its view if it wants to. And the sorts of things we're seeing within that category would be the formal recognition of traditional owner groups, the settling of boundaries and other disputes between groups. Category 2, this is the way that the state is interacting with Aboriginal citizens. Again, we see the TRB should have complete authority, but here there should be an obligation to consult with the Victorian Parliament. So there is that voice thing that becomes an obligation, but it's still not a binding, still not binding on the Parliament itself. This would be the sorts of things we see falling within this category would be, for instance, a change to the way bail laws apply to Aboriginal youth, or maybe even the age of criminal responsibility. These things should fall to the Aboriginal Parliament. The third category is when the actions of the Aboriginal Parliament are going to impact on non-Indigenous people or interests. And here we're suggesting that there could be a process whereby legislation is passed by both parliaments. This is obviously going to be the flashpoint of negotiations. The state is not going to want to allow a parliament outside of itself to essentially impact its citizens. So we think there needs to be some kind of process there, but whereby joint legislation can be negotiated and agreed. Look, that's kind of the end of the presentation. I'm sorry if I've rushed through that. I'm sorry if there was internet connection problems. We will make this available online, so hopefully, if anything you missed, you can pick up there, or you can pick up in the paper itself, or you can contact me, and I'd be happy to talk it through with you. I think the final thought to leave you with is that, you know, the ability for people to create their own laws through democratic institutions is really the ultimate act of self-determination. And this is happening in other parts of the world. It's happening in other nations. It's not that radical a concept, and we can certainly do it here. We've tried to develop a model that gives a balance between legislative powers and other powers, and between the Aboriginal Parliament's independence and the state. But you know, our model is not definitive. Who knows if we've even got the balance right? It needs to be tested well, firstly, it needs to be tested with Aboriginal and traditional owner communities to see if it would meet their aspirations. But it would probably also require some detailed constitutional legal advice, which we haven't really had the ability to go into in this document. But we hope what we've shown is that, you know, any model you develop will have some flaws and weaknesses, but it is possible to achieve self-governance in Victoria, even though we don't share some of the circumstances that you see around the world of a remote population or a majority population. It is still possible. indeed Victoria, with some political courage and some creativity, we think can lead the way, not just nationally but internationally, in providing a form of self-governance to Aboriginal Victorians. And that's where I'll leave it. I'll now try and take some questions if I can. I might ask for one of my co-hosts to just sort of help me there.
Hi, Dan. Yeah, there's a few questions in the Q&A.
Yeah, sure.
Can you see those?
No.
Okay, just a question under, should Domain 1 under legislation include the Koori Court?
Oh, I don't know if that's Domain 1, but yeah, I think the Koori Court is an interesting example. I think that would fall under the justice domain. Yeah, I don't see why that shouldn't, the administration of that court couldn't fall within the TRB. Yeah, absolutely.
The other one is there a concern that if the empowerment is achieved through a state approach, there will be significant limitation in what can be impacted? For example, Local Government Act model does not allow local laws to be made that contradict state legislation. Yes,
I think there's a risk. I do think that's a risk, and it's something that has to be, yeah, carefully navigated. And this is the problem with the delegation model. I think, yeah, I think it's unavoidable, but yeah, I think it's something that will have to be carefully negotiated.
And John, I just couldn't quite understand the meaning of that question about population. John Altman asked a question, terrific presentation, but what about population? I'm not quite, sorry, not quite sure, John, what you meant there. Oh, hang on. In the Yukon, small population means too many Indigenous people are bureaucrats. For criticism, Paul Nadasdi reports from Yukon nations, all people are hunters.
Yeah, to be honest, I couldn't comment on that. I don't know too much about the Yukon apart from what I've read in their self-government agreements. I must say, in looking at that stuff, what I've really looked at is structures. So yeah, I apologise. Take your word for it.
That's all at the moment, unless anyone wants to ask anything else. Thanks for coming. What is the time frame for a TRB, and how can you, how does it differ from ATSIC? They're two separate questions.
What is the time frame? Well, the current process under the Treaty Act in Victoria is that the Assembly and the state are negotiating a framework for treaty negotiations. So they're not actually negotiating the treaty itself at the moment. They're negotiating this framework. I understand that's probably about a year away. I don't have direct line of sight on it, but and then I assume sometime after the next state election, there will be substantive negotiations, at which time I think a treaty will be reached, and that will include an Aboriginal Parliament, I hope, as we've set out in the paper. So it's a couple of years away, I think. How it would differ from ATSIC, I mean, ATSIC was a service provider and handed out funding and whatnot. The TRB may play a role like that in some ways, but it's what's really going to differentiate it from ATSIC is it will be a sovereign body that will have the option to pass legislation. That was something ATSIC just didn't have. I hope that answers the question.
How do you think internal ratification of state-local treaties would work?
Sorry, could you repeat that?
Sorry, how do you think internal ratification of state and local treaties would work?
I don't know. I mean, so I've seen this as drawing on the idea that the Metis are going through an internal ratification process. I don't know. I mean, the way it's been done so far in Victoria is through the election of the Assembly members. They don't have a mandate at the moment, I think, to negotiate treaty. They've got a mandate to negotiate this framework. And who knows what process will be adopted. I mean, it might be that once a final treaty is prepared, or even the framework is prepared, it goes to sort of a referendum of Aboriginal voters. It might go through a mandating process, which I think sometimes has been used in Canada. So it's rather than a specific vote, the support is built for it over time, and they require a certain number of people to kind of indicate their support before it's enacted. That I think is uncertain. For local treaties, again, I think it's not clear yet, because the question of how these treaties, I think of who's going to be entering these treaties, is yet to be finally resolved. And but traditional owner nations, I mean, in Victoria, they get together and they make a decision. So I presume that's how they'll do it this time.
A couple of other questions, or a statement from Janine saying the TRB interfering with local traditional owner business could potentially diminish our self-determination.
Yeah, look, and that's why it has to be carefully negotiated. I mean, you could have a series of if you scrap the TRB and you just have local treaties, I think you miss a whole lot of opportunity of things that can be achieved at that state level. Governments, if you look at the way government deals with traditional owner groups now through the Settlement Act process, it doesn't operate well. The government basically with every individual traditional owner group is not really leveraged to do anything. It's only, I think, when those groups act collectively that they're able to get the state to move on things. So yeah, look, I fully accept that's a touch point where we have to carefully balance the independence and sovereignty and self-determination of traditional owner groups. But I think there is opportunity there that wouldn't otherwise exist if you have a statewide body that acts collectively in the best interests of Aboriginal people.
Another question about bail laws. How would bail laws application be changed without changing the legislation? Wouldn't this sit in the Victorian Parliament's court rather than something that the TRB will be able to change after consultation with the state?
No, I don't think so. I mean, it's difficult when you get down to these very specific questions because it gets complex. I don't think so. I think there's no reason why the TRB couldn't have jurisdiction over the way that Aboriginal people are treated in custody, and could make separate laws for how they're treated and dealt with under the Victorian system. The Victorian government could delegate that power, and the TRB could implement its solutions, its legislation. I mean, I don't know if that's achievable politically, but I think it's achievable legally.
If the TRB was established, would it then be responsible for adhering to domestic and international human rights standards?
Yeah, well, I believe it should be. Yeah, and what we see in Canada is, as I didn't go into this in too much detail, but you have all of the self-government arrangements, all of the citizens of those First Nations remain Canadian citizens. They have all the rights of Canadian citizens, and they have the protection of human rights legislation. So all of that would continue to apply to individuals. There are questions, I think, too, about how the TRB would, I mean, when you have a state government, as a democratic institution, there's all sorts of things that go along with that. There's courts, there's rights to have decisions reviewed in the courts. There's the right to take the state to court to make sure they have complied with human rights obligations. I mean, I think all of those things would have to continue to apply to a TRB. There is a question of whether I think they try to do that internally, or they sort of rely on the Supreme Court of Victoria, for instance. That's a very complex question and probably not a very clear answer, but yeah, I think there is some stuff in the paper on that too.
Unless there's any further questions, I think you might have answered them all, Dan.
We've gone right to time. Perfect.
Any further questions?